Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor, and or felony punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself. In this, you have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If for whatever reason during any point in this proceeding you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth.
All right, everyone get ready, because this court hearing is about to take a surprising turn. Today we are looking at a legal dispute involving Mr. Birch, a successful businessman who owns several companies and has built significant wealth over the years. On the other side is his former wife, Miss Carpenter, who divorced him some time ago for personal reasons. She has now returned to court not for closure but to seek additional financial support, which has raised many eyebrows. The judge handling this case makes it clear from the start that this courtroom is not a place for drama or emotional games. He keeps the focus firmly on the facts, the law, and the history of the case. His calm and firm approach sets the tone and makes it clear that only solid evidence will matter here. There is no room for exaggeration or personal attacks, and every claim is examined carefully. As the hearing moves forward, it becomes clear that this is not just about money but about responsibility, fairness, and legal boundaries. The judge listens patiently but does not allow the discussion to drift away from the core legal issues. His responses are sharp, controlled, and grounded in law, which makes this hearing especially interesting to watch. This case raises important points about post-divorce financial claims and where the line is drawn by the court. Viewers are left to think about whether this request is justified under the law or if it goes beyond what is reasonable. The way the judge addresses these concerns turns this hearing into a strong example of how courts are meant to function.
And so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing. Or
You wish to have a preliminary examination?
preliminary examination, yes.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, with no hearing date scheduled. So I'm hoping to sort of reconcile both of those things as whether or not discovery is something the defendant is prepared to move forward, and if he ever does file a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong, as far as anything that they've submitted. So it was improper for the wording, Your Honor. I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12 noon, that is before me.
Thank you, Your Honor.
And continue.
So let me get this straight. She filed a motion asking the court to raise child support because her 14-year-old suggested it. That alone makes this situation hard to take seriously. Courts are built on evidence law and responsibility, not teenage advice. Allowing a minor to influence legal strategy sets a very strange tone for this entire case and raises real concerns about judgment. And then it gets even more confusing. She starts reviewing his online professional profile, trying to estimate how much his private business might earn. This is not an investigation unit, and online profiles are not financial records. Running a company is complex, and profits are not something you can calculate by scrolling a page. This approach shows a clear misunderstanding of how businesses and income actually work. Now let us talk about the financial side of this situation. Nearly $1,900 each month for 2 children is already a significant amount of support. That level of payment is meant to cover real needs and daily expenses. It is not a small contribution, and the court will want clear explanations for why more money is being requested. This leads to a larger issue about expectations and responsibility. Support payments are designed to help children, not replace personal effort or long-term planning. The court looks closely at whether requests are based on genuine need or unrealistic assumptions. Every claim must be backed by facts, not feelings or outside influence. This case quickly turns into a lesson about how legal systems work and what they will and will not consider. Emotional arguments and informal research do not carry weight in court. As we move forward, it becomes important to separate reason from reaction and focus on what the law actually supports. School. The moment everyone has been waiting for is finally here, and the judge is clearly ready to make his move. You can feel the tension in the room as the decision hangs in the air. This is the point where everything shifts and one side walks away disappointed. The judge's expression tells its own story. That confident smile suggests he already knows exactly how this will end. It feels like he is prepared to cut straight through the noise and focus on the facts that actually matter. This is not the look of someone unsure or hesitant. Now the spotlight is firmly on the motion to increase child support. The court must decide whether the request is justified or whether it goes too far. This is where careful reasoning outweighs emotional arguments and assumptions. Whatever comes next is going to leave an impression. The ruling is about to set the tone for how this case will be remembered. All eyes are on the bench as the judge prepares to speak and bring clarity to a situation filled with tension and expectation. School. Watching that ruling unfold was honestly very satisfying from start to finish. The judge wasted no time breaking down the request and made it clear that the attempt to take more money was not supported by facts or logic. You could tell he was confident in his decision and completely aware of what was really happening in that courtroom. What stood out most was how directly the judge addressed the situation. He did not dance around the issue or soften his words. He identified the request for what it was and shut it down with clear reasoning. Moments like this remind people that courts are meant to rely on evidence and fairness rather than emotion or pressure. This case also brings up a larger conversation about child support and how it often plays out. Many fathers feel like the system places a heavy burden on them without always considering the full picture. Men work long hours, build businesses, and try to provide stability, yet still find themselves facing repeated financial demands. Child support is